Arbitration is one of the most attractive dispute resolution mechanisms, particularly for commercially minded disputants. However, arbitration is relatively expensive to fund. This is because, in addition to paying legal fees, parties to the arbitration are expected to pay for the cost of administering the arbitration. Added to these heads of cost is the burden of sometimes having to pay a counterparty's portion of the fees in the event that such a party refuses to pay. Welcome to B&I Talk Show Series. On the series today, we'll be focusing on issues relating to the cost of arbitration. My name is Oluwamayokun David. I'm an associate with the Litigation, Arbitration, and Alternative Dispute Resolution Practice Group of the firm, and I'm here with
Sixtus Iwuoha, Senior Associate.
Alright, like I said before, we'll be focusing on issues relating to cost of arbitration. Sixtus, I know you're a well-experienced practitioner in this space. Could you please tell us what the rules say in this regard?
So for arbitrations, we have seen costs, specifically payment of advance of the costs, present itself in almost all of the arbitrations. And what we'll find in practice is that most times one of the parties, usually the respondent, either fails or refuses to pay its own portion of the arbitration cost. And now, for institutional arbitrations, which are arbitrations administered by different institutes, the respective rules governing those institutions provide for payment of advance of cost. And probably to give a jurisprudential basis for why this is important, domestic courts, as we already know, are publicly funded, so issues around cost is not a problem. But for arbitration costs, parties need to bear the expenses for the arbitrator's fee, and for administered arbitrations, they also need to pay the administrative cost of those arbitrations. In no particular order, let's even begin with the ICC rules. The ICC is the International Chamber of Commerce, and in its current rules, which is the 2021 rules, in Articles 37 and 38, it provides for the powers of the court, which is the International Chamber of Commerce Court, to set what the arbitration cost is. And before the arbitration typically progresses, the tribunal invites the parties to pay their respective portion of the arbitration cost, which is usually on a 50-50 basis. And both parties are given a certain number of days to pay their respective portion. Where one party pays, usually the claimant, and the respondent fails to pay, the claimant is obligated to pay the respondent's portion. And where the claimant fails to pay the respondent's portion, the ICC rules provides for the Secretary General of the ICC to then instruct the tribunal to suspend the arbitration and thereafter set a timeline which is no longer than 15 days for the fees to be paid. At the expiration of the 15 days, where the fees remain unpaid, then the claims will be deemed to have been withdrawn. So if, for example, the claimant fails to pay its own portion of the advance costs, the claimant's claims in the arbitration will be deemed to be withdrawn. In the case of the respondent, where the respondent has filed a counterclaim but has refused to pay its own portion, then the counterclaim is deemed to have been withdrawn. Secondly, let's consider another rule. So let's go to the Hong Kong International Arbitration Center rules. And I know it provides in Articles 41.4 and 41.5 for the powers of the tribunal to set the arbitration cost. And just like the ICC rules, it allows the claimant to pay the respondent's portion. And instructively, after paying the respondent's portion, the claimant is not without the remedy. The claimant can seek to claw back what it has paid on behalf of the respondent, either at a later stage of the proceedings, usually at the end of the proceedings, where parties are invited to make their submissions on cost. And in rendering the final award, the tribunal is also obligated to consider or to note the fact that one of the parties, in this case the respondent, has not paid its own portion of the fee. So it takes into account that In the International Center for Dispute Resolution rules, he also provides for the powers of the tribunal to set the arbitration cost. And in Article 39, he allows, or rather obligates, the claimant to pay the respondent's portion where the respondent has not paid. I'm using the respondent here because the respondent is usually the party who has failed, who usually fails to pay its own portion. But if you go under the rules, you see language around if a party fails to pay, but we already know who the culprit is. Then lastly, let's consider what the rules say in the London Court of International Arbitration, the LCIA. We see provision, I believe, in Article 26.4, which allows the claimant to pay the respondent's portion where the respondent has failed to pay. And for ad hoc arbitrations, let's take, for example, arbitration conducted under the ACA, which is the Arbitration and Conciliation Act. The rules also provide for the tribunal to fix what the arbitration cost is, and thereafter demand for an advance. It provides that once that arbitration cost is fixed, the parties have a set number of days. The ACA says 30 days. And where either party fails to pay, fails to pay its own respective portion, the party who has failed is invited to pay the defaulting party's portion. And where that doesn't happen, the tribunal has a power to either suspend or terminate the proceedings. So, broadly speaking, that is just a bird's eye view, or if you like, a dashboard view of what the rules say.
Thank you very much. I mean, that was very insightful. I hear you say that, I mean, in certain respects, maybe in most respects, the respondent may not be very willing to pay its portion of the cost of the arbitration. In the event that this occurs, and I guess in practice it typically occurs quite often, what remedies will the claimant have if it pays the respondent's portion of the costs?
Well, thank you for that question, Mayokun. What we have seen in cases where a party fails to pay its own portion, usually the respondent, the courts are not settled on a point. And what we'll find is the failure or refusal to pay has been construed in different ways. There's a school of thought that sees that failure to pay as contractual. There's another school of thought that sees it as procedural, and I will explain. When parties enter into an agreement to settle their dispute by arbitration, there is an implied contract that the arbitration cost will be paid by the parties. So where a party therefore fails to honor that obligation to pay, the party who has paid can construe that as a repudiatory breach, which goes to the root of the contract. And in that particular case, in such cases, the party is actually entitled to deem the respondent's failure as a waiver, and the party is well within its rights to then commence proceedings in court in relation to the same disputes. Procedural, in the sense of procedurally, the courts have considered it that for most institutions that the requirement to pay the arbitration cost is a procedural duty owed by the relevant arbitration institution towards the parties, as against a contractual obligation owed by the parties to themselves. So they have considered it in this respect, and some cases come to mind. For example, I know in the UK decision of BDMS Limited against Rafael Advanced Defense Systems, which incidentally had to do with an ITC arbitration, the respondent failed to pay its own portion, pursuant to which the claimant, which is BDMS, approached the court for the ventilation of the dispute. And the reason he gave was it was not obligated to pay the respondent's portion, and the respondent's failure to pay its own portion amounts to a repudiatory breach. Even though the court did not agree with the submission, relevance referrals were made to decisions in other jurisdictions. I know the decisions in Canada was considered specifically in the province of Alberta in the case of Racing Incorporated against Industrial Services and Machines Incorporated. where the court held that the respondent's failure to pay its own portion of the arbitration fee rendered the arbitration inoperative, and as a matter of fact, paralyzed the arbitration proceedings. By and large, in such cases, the point is that a party who has paid is not without a remedy. Such a party can deem the failure or the refusal of the defaulting party as either a repudiatory breach that nullifies the arbitration agreement or renders it unworkable, or such a party can go ahead and pay the respondent's portion and subsequently bring an application before the arbitral tribunal to claw back what it has spent. All in all, in approaching or preparing for an arbitration proceedings, it's important for the claimant who issues the notice of arbitration to do some accounting diligence and properly ring-fence appropriate monies that will go into securing or paying for the advance of arbitration costs in the unlikely event that the respondent fails to pay its own portion.
Thank you very much, Sixtus, for the insightful talk. So, in recap, for every claimant who is going to issue, preparing to issue notices of arbitration, first of all, the claimant would need to deeply plan and consider that the cost of arbitration is very important to its eventual success. And as such, proper planning needs to go into what claims are submitted to the arbitral reference and the budgeting also for paying up the portions of the cost. Secondly is that in the event that the arbitration progresses, the claimant will be invited to pay up the respondent's portion of the cost of arbitration should the respondent fail to pay up according to the timelines either agreed by the parties if it is an ad hoc arbitration, or the timelines set up by the rules of the arbitration if it's an arbitral reference governed by institutional rules. The third thing to note and to take away is that the claimant who eventually pays off the respondent's portion of the fees is not without remedy.
Sure.
You could claw back those amounts spent on account of the arbitral reference and the respondent's failure, and you could also take up other proceedings to get those monies back. Thank you very much for your time and for watching. Please watch out for more to come from B&I on the Talk Show Series. Thank you.
Thank you.